my niggas turn shooters. All my ops turn rats. All my niggas turn shooters. On the internet, you ain't been his friend. You been stuck in a computer. Show me the proof. All my niggas turn shooters. All my niggas from the hooters. All my niggas from the hooters. All my niggas turn shooters. All my ops turn rats. All my niggas turn shooters. On the internet, you ain't been his friend. You been stuck in a computer. Show me.
The fact that on February 24, 2018, plaintiff just went home and took a nap is corroborated by plaintiff's own T-Bell cell phone records for that day. As you'll see, and this was an admitted exhibit, you'll be able to see it, it's exhibit 200. She gets calls and she makes calls from 11:20 a.m. all the way to 3:35 p.m. and then nothing until 9:08. That's when she took her nap. That's what she did. She didn't call a doctor. She didn't go to the hospital. She didn't put a Band-Aid on her face. She took a nap. Now, importantly, when plaintiff testified as her own first witness in her case, she admitted that in 2021, she hit her head in a car accident. She's put on no proof that that wasn't the source of the scar, which is a pretty obvious reason that she would have a scar if she had one. And importantly, 2021, a car accident in 2021 is after plaintiff told Dr. McKenna in April 2018 that Cardi almost touched her with a fingernail. Not touched her with a fingernail, and I'll talk more about that later, but almost touched her. So after the plaintiff tells Dr. McKenna, her workers' comp physician or psychologist, that Cardi almost touched her, plaintiff was then in a car accident, hit her head, and that's when she went to Dr. Mulligan. She went to plastic surgery 4 years later after being in a car accident.
Objection on this case.
Plaintiff also testified, by the way, that she was in another accident in 2023 and filed another lawsuit over that one. Plaintiff has argued, and he said again today, that plaintiff's counsel has argued and said again today that plaintiff has some special status as a security guard. But she testified she became a security guard by having her fingerprints taken and sent to California. That's it. That doesn't make her a policeman. Also importantly, when testifying last Monday, plaintiff admitted that she knew on February 24, 2018, that Cardi was in the medical building because Cardi was going to a medical appointment. Plaintiff's own testimony establishes that at 1:30 p.m. on that Saturday, plaintiff could have been at that security guard booth that counsel showed you a photograph of. She could have been on her rounds, going through the whole building. She could have been in parking, checking, because that's what security guards do. But plaintiff, who has testified she was a fan, just happened to be outside Dr. Finke's office when Cardi B was showing up to see an obstetrician. From those facts alone, you can infer that she was actually laying in wait. She wanted to photograph and videotape Cardi. She would then be able to post it on YouTube, maybe start a new career, be a follower. I don't know. But from the facts you've seen in this and heard in this case, she very well could have done that on purpose. But even if we assume that plaintiff just happened to run into Cardi B in a 5-story building that afternoon, plaintiff testified that she knew Cardi thought that plaintiff was using plaintiff's phone to tell someone that Cardi was there and to videotape her. What would a reasonable person do at that point? By her own testimony, plaintiff had the chance to be professional and avoid all of this by putting her phone away. That's all she had to do. But the evidence is she kept that phone in her hand all the way through as she advanced on Cardi B and forced her into a corner in the hallway where Tiara Malcolm found her. Plaintiff also testified that after she was fired as a security guard, she got a new job that paid more money. That's why you don't hear any claim for lost wages or anything like that. She was better off.
Not claiming lost wages.
That summarizes what plaintiff testified to, and I'll talk later about the inconsistencies in it. But let's talk about her second and third witnesses, plaintiff's mother and grandmother. Both very charming. But her mother and her grandmother weren't in the hallway that afternoon. Her mother and her grandmother were not witnesses. And they testified that because plaintiff is the mother's daughter or the grandmother's grandchild, that they believe her. They don't need evidence. They just hear what she says. And that's understandable, of course. We all have relatives and we hope our parents believe us and and our grandparents. But remember what Judge Fusselman said at the very beginning, common sense. Okay. We all know that parents are not with their children every minute of the day. We all know that children don't always tell their parents everything. And they especially do not tell their parents that they're embarrassed or guilty about what got them fired. That's what plaintiff left out when she talked to her mother and her grandmother. Is anyone surprised that plaintiff did not tell her mother and grandmother that plaintiff cursed and yelled at a pregnant Cardi half her size, that plaintiff cornered Cardi in a medical building hallway, and that plaintiff knew she was probably going to get fired? Is that the kind of thing you'd say? Guess what, Mom? Guess what I did today? So it's completely understandable, using common sense, that the mother and grandmother would not know actually what happened. In fact, plaintiff didn't tell them that she had apologized in her incident report to Allied and the building for her own behavior. She left that out because I asked both the mother and the grandmother, did your daughter or granddaughter, tell you that? And they said no. So we know that plaintiff left that part out. Plaintiff's mother and grandmother both said that plaintiff is a peacemaker. Okay. Well, that sure doesn't square with the testimony of Tierra, Malcolm, Dr. Finke, or Cardi, and I'll discuss that later. And maybe what we take from that is she's a peacemaker when she gets her own way. We know what she's like. We've heard testimony what she's like when she doesn't get her own way. But there's another word for that other than peacemaker. It's a bully. Plaintiff's mother and grandmother both said they saw a scar on plaintiff's cheek. But on February 26, 2018, 2 days after the incident, plaintiff emailed her incident report to her super Jasmine, stating that Cardi scratched plaintiff's nose. So how is it that the mother and grandmother are saying that, well, when this happened or around that time, our daughter said that Cardi had scratched her cheek. But in plaintiff's own incident report, she said she told her supervisor Cardi scratched her nose. A nose is not a cheek is not a nose, and there is something wrong about what's going on because, again, apply common sense. Plaintiff's mother testified that she saw a scar, but she didn't testify when she saw it. Counsel asked her, did you notice after the incident that Emani Ellis had a scar to her face? Answer, I did. When did she notice that? 2018, 2019, 2020? We don't know. And in response to one of your questions, because the judge was kind enough to allow jurors to ask questions, which doesn't happen all the time. You were lucky in that regard. One of your questions, the judge read, and in response, plaintiff's grandmother said she spoke with plaintiff right after the incident. Right after the incident, she spoke with plaintiff. But plaintiff testified last Monday. Question, you didn't call your grandmother though, did you? Answer, no. Okay. So again, common sense tells you something is very wrong here. Now, plaintiff's mother and grandmother testified that plaintiff became depressed. If so, there could have been many different reasons for it. And for example, it could have been because she got fired. And as we'll see in a few minutes, she felt guilty. That's what plaintiff told Dr. McKenna in April. On April 26, 2018, plaintiff told Dr. McKenna that she feels guilty. Ultimately, the testimony of plaintiff's mother and grandmother just doesn't move the needle for plaintiff. They weren't there. And they're relying on what plaintiff told them. Now, plaintiff's third group of witnesses is Dr. Mulliken. And that's what she offered to support her claim. Of course, Dr. Mulliken also wasn't there on February 24, 2018. He didn't witness what happened. Dr. Mulliken testified that plaintiff came to him in November 2022, or more than 4 years after the alleged incident. Dr. Mulliken is a plastic surgeon, not a psychiatrist. So counsel pointed out that Dr. Mulliken testified that plaintiff told him she has post-traumatic stress, anxiety, depression, and headache. But Dr. Mulliken said, that's what she told me. I did not make a diagnosis to that effect. That's just what she told me. Now, Dr. Mulliken, and I hope he's not insulted, but his testimony was confusing and inconsistent. He testified that in November of 2022, plaintiff had a scar, had 2 to 3 scars, had 3 scars, and even plaintiff doesn't claim that she has more than 1 scar. But Dr. Mulliken thought there were as many as possibly 3. Somehow the no scar from the beginning turned into 2 scars and then 3 scars. Also, though, Dr. Mulliken's own photograph, Exhibit 228, which he testified was taken with a digital camera before any treatment, sure doesn't appear to show the scar. That is you'll have a copy of the actual photo. It's admitted as exhibit. You can look at it and you can decide. Counsel actually challenged you, look at the photograph, and we invite you to. If you see a scar, that's news to us. And this is before she was treated. Importantly, Dr. Mulliken testified at his deposition. You've all heard about depositions. They're under oath. It's just like a trial, except there's no judge. And that the claim scar was about an inch long and most likely made by a right-handed person who scraped or clawed downward with 3 fingers. Okay, that's what he testified to. That's what was in his deposition, and that's what he testified to here. But plaintiff herself claimed in her deposition that Cardi jabbed her with a straightened index finger, like this. That's not a scrape. Your Honor, I don't think I need to ask for permission, but we'd like to show then we'll show, this was played for the jury before.
Okay.
It's Cardi's testimony, plaintiff's testimony as to how she was supposedly cut by Cardi.
When you say it like this, she put her finger.
Pointing, yes, so like this, pointing her finger in my face, yes.
That is directly and irreconcilably in conflict with Dr. Mulliken's testimony that it was a right-handed person who scraped with an index finger and 2 other fingers downward. Those are completely different things. They don't correlate. The testimony is clear that plaintiff and her plastic surgeon have completely different explanations for the same claimed scar. And once again, common sense. Something's wrong here. Something is very, very wrong. Now, maybe the scar that Dr. Mulliken says he saw and his explanation, maybe it was a car accident. I don't know. But it is irreconcilable with plaintiff's own testimony that she was jabbed with the straightened finger. And to add to that, Cardi is not right-handed. I want to say that again. It's very important. Dr. Mulliken says that in his professional opinion, and counsel talked about it, how well-respected he is, that it was a right-handed person who scraped 3 fingers downward across plaintiff's face. But Cardi is left-handed. She is not a right-handed person and could not have done that. Plaintiff's counsel tried to get Dr. Mulliken to testify that a left-handed person might have made the claim scar, but that's not his opinion. He admitted that it would be hard, in fact testified it would be hard for a left-handed person to reach across and strike a person on the opposite them on the left side of the face. Now, here's another important thing. Dr. Mulliken testified that he can't say when plaintiff got the claimed scar. He testified there's no way of knowing the age of the scar. That's important because plaintiff admits that she hit her head in a car accident in 2021, almost 2 years before the November 2022 appointment with Dr. Mulliken. And Dr. Mulliken also testified that he can't say whether the claimed scar was caused by an intervening accident or some other cause.
Objection that misstates the testimony.
Ladies and gentlemen, you heard the evidence. Please rely on your recollection of the evidence and rely on your own recollection to the extent that it differs from counsel's representation.
And Your Honor, we also have a cite to the reporter's transcript. There are other odd things about Dr. Mulliken's testimony. For example, he calls a 3-minute long session of outpatient microneedling a small part of plaintiff's cheek, which serves, well, as reconstructive surgery and plastic surgery. A 3-minute microneedling session in his mind is reconstructive surgery and plastic surgery. Now let's talk about why he would say that. He has a broad version of surgery that enables him to charge an additional $11,000 for an operating room. He testified surgery is anything that includes a doctor, a nurse, a scrub technician, and an operating room. No matter what you're doing, even if it's microneedling, if it's pulling a splinter out, you go into that room and he charges $11,000. Dr. Mulliken testified he is the sole owner of the surgery center with that operating room. So he has a strong financial incentive to use and charge for that operating room, whether he's doing real reconstructive surgery or microneedling. Now, perhaps because his photograph doesn't seem to show the claimed 1-inch scar, Dr. Mulliken also provided confusing testimony about hidden scars under the skin. I don't know if you remember that. It had my head spinning. But he never testified. There's no testimony from Cardi, from Dr. Mulliken, or anyone else that plaintiff has a hidden scar. In fact, it's supposed to be this, really big embarrassment that she has this, terrible scar on her face that, you can decide whether you've seen it. You've walked by her. If you see a scar, well, no one else. A lot of us don't, I should say. Dr. Mulliken also testified that he charged $17,500 on a lien basis, which means he gets paid only if plaintiff wins or if plaintiff pays him. But plaintiff testified under counsel's own examination on Monday that she couldn't afford a $15,000 or $20,000 plastic surgery bill. So we know she's not going to pay Dr. Mulliken. Dr. Mulliken knows that he is going to get paid, if at all, the $17,500 only if his testimony helps plaintiff recover money in this case. That is a big incentive. And because of that risk, he testified he added a 20% premium to his bill. That's plaintiff's side of the scale, which keeps disappearing. And it pales in comparison to Cardi's side. So, of course, Cardi's evidence starts with Cardi's testimony, which will appear shortly. Thank you. Cardi is one of the 3 eyewitnesses who directly contradict plaintiff's story about what happened that day. Cardi testified that in February 2018, she was pregnant. You may remember in this trial that plaintiff's counsel asked Cardi, why does that matter? You're pregnant. No one knows, but why does that matter? Well, it did matter, and Cardi testified, and you should consider, and I hope you remember Cardi's response. She felt her privacy was completely being violated and that her medical issues are not anyone's business. Quote, especially something that is so sacred as your pregnancy. It's yours. No one knew she was pregnant. Her parents didn't know. And she shows up for an appointment, and this woman is photographing, filming her, and then getting belligerent. Now, I mentioned that Cardi testified her parents didn't know she was pregnant at the time, and it's common sense that no daughter would want their parent to find out that she's pregnant by social media. This was a secret. There were special arrangements made so that she could see an obstetrician while in LA on a Saturday. Now, Cardi testified that she came to Los Angeles for the NBA All-Stars weekend, and concerned, she made an appointment with the obstetrician for Saturday afternoon. I'll get to the photograph in a minute. Cardi testified that she got off the elevator to go to the doctor's office at about 1:30 on the 5th floor of that building, and plaintiff started filming and photographing her. Cardi objected, and plaintiff apologized at first, saying, "Oh, my bad," which is effectively an admission that she was doing what Cardi thought she was doing. Cardi testified that plaintiff wouldn't stop and just kept following her with her camera, with her phone out. Cardi testified that she was very concerned and nervous and confused by plaintiff's conduct. That is understandable. Cardi testified that she was concerned about her unborn child. Cardi referred to plaintiff as security heavy. She's a large woman. She's almost twice the size of Cardi. Cardi's pregnant, early in her pregnancy, and this person comes up to her in black boots and starts yelling at her. Cardi was concerned about her, and scared, frankly, about what she might do to her unborn baby. Cardi also testified she was confused. Why is this going on? Why is a security guard doing this? Why is she filming me? Why is she following me? Cardi also told plaintiff specifically that plaintiff was invading her privacy. But when Cardi told plaintiff to leave her alone, plaintiff went berserk. She yelled, it was plaintiff's phone. Plaintiff said, "That's my phone. This is my building. You can't tell me what to do." That's what Cardi testified, and it's consistent with what Tierra Malcolm, and Dr. Finke testified. But plaintiff advanced on Cardi, screaming and yelling and forcing Cardi backwards down to the hall to a corner, coming chest to chest with Cardi, yelling at Cardi about how, this is her building. She can do whatever she wants. Now, hearing the yelling, the doctor's receptionist, Tierra Malcolm, and then the doctor intervened and tried to get plaintiffs to stop and leave. We'll talk about that in a few minutes. In the meantime, Cardi testified that she and plaintiff yelled and used curse words, but neither struck the other. Cardi did not strike plaintiff. Plaintiff tried but did not strike Cardi. Cardi testified.
I don't want to interrupt. We're coming up on a break. If there's a logical place to stop, please.
I can stop there if you want.
Okay. All right. Why don't we stop there, folks? We're going to resume back at 1:30. In the meantime, please don't discuss the case with anyone, including other jurors. Don't form any opinions or do any research. We'll see you at 1:30. We're going to resume the defense closing argument.
Thank you, Your Honor. Good afternoon. We're back. So picking up where I left off, Cardi testified in this courtroom that the whole encounter was maybe 45 seconds, less than a minute. Counsel has urged, and I'll get back to this as well, that she didn't see what happened before, but if you add her and compare her estimates with those of Tiara and Dr. Finke, who said that it lasted about 45 seconds, it's clear that they came out right at the beginning. Now, Cardi also testified in front of you and under oath that she never spit on plaintiff. She never struck or cut plaintiff. She never touched plaintiff's face. She never used the N-word. She never threatened to get plaintiff fired. Cardi also testified that she is in fact left-handed, and we've talked already about how that undercuts Dr. Lanikin's theory that a right-handed person caused the claimed scar. Cardi testified that she didn't have any 3-inch nails at the time of this incident in February of 2018. She also testified that she was in Los Angeles. She lives back east, and she was in Los Angeles for the NBA All-Stars weekend in 2018. And we put into evidence a photograph of Cardi to prove that her fingernails were an inch or less. It's a photograph that she testified was taken at the NBA All-Star week. And you heard counsel earlier say that Cardi testified that photograph was taken on the same day of the alleged incident on February 24. That's absolutely untrue. She did not testify to that. If you are unclear, the record can be read back to you, but I expect that you were here and heard Cardi testify that she was here for a week or so and kept the same fingernails this entire time, and that includes February 24th. The assertion by counsel that she testified to something she did not in fact testify to is something that Your Honor that the judge had already indicated is something you should disregard. Now, she testified that the nails she was wearing while she was in Los Angeles were coffin square and not pointy. That was a new one on me. Apparently coffin square means the shape and the square, and it can't cut anything. She also confirmed and testified that the rhinestone images were flat. They were not pointy, and they had no sharp edges. Apparently you can get little rhinestones either as little decals on fingerprints or as rhinestones themselves. I'm not like Dr. Finke, a fingernail expert, so I won't talk about that. But the point is, rhinestones can appear on a fingernail, a decorated fingernail, either as three-dimensional or as flat, which of course flat can't cut anything. And she testified, as did Dr. Finke, well, excuse me, I misspoke. She testified that they were flat. Dr. Finke, counsel had said, testified that they were sharp. He actually testified he didn't know whether they were sharp or flat. It is very important, actually, also that while plaintiff's testimony about what happened is uncorroborated, she called no witnesses who were actually there. Cardi actually did have 2 witnesses. And we'll get back to that. I do want to mention something that plaintiff's counsel raised, which is there's testimony from Cardi that as plaintiff advanced towards her swearing and pushing her back, that their chests touched. And counsel told you that that's an assault right there, that his client wins. Well, there's a couple of problems with that. Just touching chests like that is not an assault. And if it is an assault, it's an assault by plaintiff on Cardi. Cardi was being pushed back. That's the testimony from all the both of the witnesses and Cardi herself. But I should mention, just in case you want to know, there is an instruction in the jury instructions that deals with the defense of self-defense. Counsel said that that is inapplicable here because Cardi denies that she touched anyone or had to act in self-defense or that she cut plaintiff. The point he's overlooking is that is up to you. You've heard the evidence. We think it's overwhelming that Cardi did not touch a plaintiff at any point in time and did not touch this magic appearing, disappearing scar. But we have to be careful as lawyers. So we've included a self-defense, a defense of self-defense instruction, which means that if you were to find that Cardi did touch plaintiff, or that somehow a chest-to-chest caused by plaintiff is assault by Cardi, which we dispute strongly, there is an instruction that the judge has given you that self-defense applies if a person reasonably believes that another person was going to harm her or him, and the person uses only the amount of force reasonably necessary for protection. I think there can be no doubt that Cardi was faced with someone bigger than her who was trying to hurt her. We know that from both Cardi's testimony, Tiara's testimony, Tiara Malcolm, and I believe also Dr. Finke. But let's talk about Ms. Malcolm. Tiara Malcolm, we called her as a witness, so we'll add her there. And she is one of the 4 people who are in the hallway, and she testified as an eyewitness, and she has no axe to grind. She's not a friend of plaintiff. She's not a friend of Cardi. She doesn't work for Cardi. They never met before. And so, again, she's an independent third-party witness. She testified that she was Dr. Finke's receptionist and expecting Cardi for a secret appointment. As a receptionist, she was near the front door. That's why she got out first before Dr. Finke, whose office was in the back. She testified it was a Saturday and all the other offices in the building were closed. And they closed early because, quote, they didn't want anyone there when Cardi arrived. When Ms. Malcolm, she testified that when she heard yelling, she immediately ran out. She's near the door. There's nothing she really could have missed once the yelling started. A defendant's counsel has argued that, again, that she wasn't there in the beginning, but we know from her testimony that she was near the door, immediately ran out when she heard yelling. Now we have a visual rendering based on plaintiff's own photograph of the hallway outside the doctor's office and based on the testimony and Cardi of Ms. Malcolm. This shows how far, you see the elevator bank and you see the doors that are depicted in the photograph that plaintiff showed you, plaintiff's counsel showed you. And where did they end up? They ended up in that corner. That's how far this demonstrates, based on the testimony and evidence in this case, how far plaintiff forced Cardi B backwards and into the corner that Tiara Malcolm saw her when Tiara opened the door into the hallway. Ms. Malcolm specifically testified that when she opened the door, she saw that plaintiff had Cardi against the corner. Ms. Malcolm testified that she said, "What are you doing? You're at work. Go back to your post." And that the plaintiff just refused. She was going after Cardi. She was yelling, screaming. Ms. Malcolm testified that she got between them with Cardi behind her and with Ms. Malcolm facing plaintiff. The evidence is that at that point, Ms. Malcolm testified that plaintiff was swinging at Cardi, who was behind Ms. Malcolm. That's what she testified to. Now, Ms. Malcolm didn't realize at first that she was hit. She went after Dr. Finke came out and tried to deal with the plaintiff. Ms. Malcolm took Cardi into the office and someone else at the office, this is what she testified, what Ms. Malcolm testified to. Someone else at the office said, "What happened to your head?" That's when she found out. In all the brouhaha, she did not realize with Cardi behind her and plaintiff in front of her swinging away, Ms. Malcolm did not realize that she had been hit. Now, counsel told you in his opening statement that Ms. Malcolm didn't know she was hit. She knew she was hit. She went back to the office and she saw the scratch on her own head. Counsel has argued
Your
that
Honor, I would object to him referring to counsel. We can talk about facts, not counsel.
plaintiff's counsel has argued to you that Ms. Malcolm didn't know who hit her. Okay. And he dwelled on that a lot in his cross-examination of Ms. Malcolm. And with all the things flying, with all of plaintiff's hands flying in the air, what Ms. Malcolm explained is her back was to Cardi. Ms. Malcolm specifically testified she did not see Cardi's hands go in front of her, go by Ms. Malcolm's head. But she did see plaintiff flailing away trying to get to Cardi. That's why she concludes that it was plaintiff who hit her. And it only makes sense. Cardi was behind Ms. Malcolm, and Ms. Malcolm was hit in the forehead, face to face with plaintiff. Again, I apologize for the language, but it's important that you hear this. Ms. Malcolm also heard plaintiff, who was almost double the size of Cardi, expressly threaten in no uncertain terms to harm Cardi. Quote, "I will F your shit up." That's what Tiara Malcolm testified to. She heard plaintiff threaten Cardi. That's an express threat. If anyone was being assaulted by threats of immediate offensive contact, it was Cardi who was being assaulted by plaintiff. Ms. Malcolm testified that while Cardi was behind her and Ms. Malcolm was face to face with plaintiff, Ms. Malcolm did not see any scratches or cuts on plaintiff's face, any blood on plaintiff's face, any injury at all on plaintiff's face, or any spit or spittle on plaintiff's face. Ms. Malcolm also testified that Dr. Finke came out of the office into the hallway and tried to get plaintiff to stop and leave. Ms. Malcolm then got Cardi into the doctor's office. She testified that throughout this, plaintiff had her phone in her hand. I want to repeat that. So she testified here that she was using earphones. We've got another witness who says plaintiff was standing there, flailing away with her phone in her hand. Now, Ms. Malcolm also testified, and I know this gets a little bit repetitive, but it's important you remember this testimony and you take it into account when you deliberate. Ms. Malcolm also testified that Cardi did not hit plaintiff, that Cardi did not cut plaintiff with her fingernails, that Cardi did not use the N-word. Ms. Malcolm testified with Cardi behind her, almost touching her back. She did not see or feel Cardi swing at plaintiff. They didn't touch each other, although counsel asked, what about chest to chest? And Ms. Malcolm testified, which seems truthfully, when plaintiff had Cardi in a corner, Malcolm could not tell if their chests were touching. That's because she's behind them. She's coming out of the office door. Ms. Malcolm also testified that a few months later, plaintiff asked Ms. Malcolm to help her go after Cardi. Now, if you remember, counsel for plaintiff elicited testimony from plaintiff that she never really intended to sue Cardi. She never intended to go after Cardi. But that's not what Ms. Malcolm says. Ms. Plaintiff was trying to elicit witnesses to support a claim against Cardi. And Ms. Malcolm said, thank you, but no thank you. And she did that because she felt that plaintiff was at fault and, quote, she handled everything unprofessionally, close quote. Now, we also called Dr. Finke. He too was there the day of the incident, and he too has no axe to grind. He is not her regular doctor and never has been. He saw her that one occasion on February 24, 2018, when Cardi was here for work for the NBA All-Star Weekend and was concerned. She was pregnant. She wanted to see an obstetrician, and an appointment was made. He is a completely disinterested third-party witness with no axe to grind. Now, Dr. Finke, like Cardi and like Tiara Malcolm, testified that plaintiff, well, first of all, he testified his office was at the back of the suite. He heard yelling, and he immediately ran to the front. Okay, so he gets there very quickly too. And he just has a little bit more distance to cover. And he testified, like Cardi and like Ms. Malcolm, that plaintiff had her cell phone in her hand. He saw plaintiff trying to hit Cardi. He saw poor Ms. Malcolm in the middle. And by the way, do you remember in the opening, counsel for plaintiff said, well, Ms. Malcolm threw herself into the fight. If she gets hit, she gets hit. That's what happens when you try to help. I mean, really? I mean, she's a doctor's receptionist. She sees a patient coming there for a secret appointment, a pregnant patient. She tries to stop a security guard who's got the patient cornered in the hallway. And that's like, she asked for it? Is that really the answer? Dr. Finke also testified that Ms. Ellis had scratched plaintiff had scratched Malcolm's head. If you remember, the evidence is that Tiara Malcolm did not realize she was scratched until someone else in the office, the doctor's office, pointed it out. And also that Dr. Finke, once he got plaintiff to leave, which she refused to do, that he went back into the office. So he had a chance to see her at that point. That supports his testimony that he saw the scratch on Malcolm, not on plaintiff. Dr. Finke also testified that he told plaintiff, do your job, you're a security guard. But plaintiff kept yelling and she refused to leave. Kept yelling at them, kept yelling at Cardi. Now, while Dr. Finke tried to get plaintiff to leave, he was face to face with her. He testified they were within a foot of each other. And he testified he saw no cuts or scratches to plaintiff's face. He saw no blood on her face. Despite the fact that he testified that a cut on one's face bleeds more than a cut on any part of the body. This woman claims that she was cut in that encounter, but no one has testified that she had blood in her face. In fact, she testified she doesn't know if she had blood on her face from a scratch that has supposedly ruined her life. He also testified that he saw no spit or spittle on her. He also heard, he was there when plaintiff expressly threatened harm to Cardi by saying, I will F your S up. Now, Finke testified that Cardi did not spit on plaintiff or anyone else, did not take a swing at plaintiff, did not hit plaintiff, did not cut or scratch plaintiff, did not threaten to get plaintiff fired, did not use the N-word, and did not call plaintiff fat or poor. Dr. Finke also testified that once Cardi was safe in his office, he examined her in an examining room, and she did not have 3-inch fingernails. Now, in an interesting term, that was a surprise to me as well. He said he actually notices his patient's fingernails because it's a way of calming them down. It's a way of lightening the mood in the examination. So he's seen a lot of fingernails. And he looked at hers, and hers were not 3 inches. There were allegations, and you've heard little bits of it, that Cardi supposedly got plaintiff fired. Actually, Dr. Finke said it was him. He told his practice administrator, that this was outrageous, and based on the conduct he saw, plaintiff had to go. Cardi did not make a complaint. Cardi is not the reason that plaintiff got fired. Plaintiff is the reason that plaintiff got fired. Our evidence also included plaintiff's February 24, 2018 incident report. Plaintiff was asked in discovery, and we read some of that to you, which are formal written requests for documents or information, sworn under oath by plaintiff in this case. We asked for documents relating to the incident, emails relating to the incident. She never produced her incident report. We had to subpoena it from Ally. That's how we got it. We didn't get it from her. She claimed it didn't exist. Once again, common sense. There's something wrong there. We had to serve a subpoena on Ally, who produced a copy of the incident report, and we relied on that incident report because of plaintiff's inconsistencies and admissions. Now, it contains a lot of her accusations, and we believe the evidence is clear that they are false, but it also includes some interesting statements by plaintiff. And this is 2 days after the February 24, 2018 incident. Plaintiff, who testified, if you remember, that incident reports are very important. And she testified, and in the incident report, she told her supervisor that that Cardi had scratched plaintiff's nose. Not cheek, nose. 2 days after the incident, when she's blaming all of this on Cardi, which I think it's safe to assume that she was improperly doing so, given all the evidence we've heard. Plaintiff told her supervisor 2 days later, Cardi's with 3-inch nails, the evidence is against that as well, scratched plaintiff's nose. Nothing about a cheek. And again, a nose is not a cheek. They're different. This raises 2 points, really. Plaintiff's first statement that Cardi scratched her nose is directly contrary to plaintiff's sworn testimony here that Cardi scratched her cheek. Okay. So if we accept that, then the statement that she put in her report is clearly false. Because she's now saying, and she's been saying for a couple of years, no, it wasn't my nose, it was my cheek. Second, plaintiff admits that her nose was not scratched. So this is a very important document because it confirms that she made false statements about the incident. At a minimum, she made the false statement that Cardi had scratched her nose. This statement, this incident report that she said is very important, also apologized to Allied and the building owner, quote, for behaving the way I did. Okay? Why would she apologize to them if she was attacked? Why is it something that she would apologize for? Again, common sense. She was apologizing because of the way she was behaving. She's apologizing to them for her professional misconduct. She's apologizing to them for attacking a medical patient who's trying to go in for a medical exam.
So you can wrap up in about 10 minutes?
Can I have a little bit of extra time since counsel got extra time?
I don't know that he did, but please try to wrap up.
Okay. I'm going to do this a little bit faster, and I apologize. We also called Nicole McKenzie. Nicole McKenzie is an interesting person because she's a psychologist, a workers' comp psychologist, and plaintiff called her too. It's baffling why he did, because all of her testimony only helped Cardi. First of all, no one called Dr. McKenzie as a psych witness. There were no psych witness questions. We called her because what plaintiff told Dr. McKenzie in April of 2018, just 2 months later, is directly contrary to what she's been saying. Ms. McKenna testified that let me rephrase this because I'm trying to cut some of this out. Ms. McKenzie, who you may remember, testified in this case that everything that she was saying was what plaintiff had told her. And she testified that when Dr. McKenzie did the evaluation, plaintiff made no mention of being scratched, cut, or even touched by Cardi. She actually said Cardi, quote, almost, close quote, touched her. Almost is not touching. Plaintiff has offered no explanation as to why she told Dr. McKenzie Cardi almost touched her. Ms. McKenzie also testified that in doing her evaluation, she would note any physical symptoms. And she confirmed that plaintiff identified no physical symptoms 2 months after she supposedly got cut in this incident. In response to one or more of the jurors' questions, the judge elicited the response from Dr. McKenzie that it was her standard practice that even if someone came to her just for a psychological examination, that she would also note any physical symptoms that were reported, and also that if she saw the patient and saw, if they've got a cut or scrape or a bruise or whatever, she'd note that as well in the report. And none of that was noted because none of it existed. We also asked plaintiff about her Kaiser medical records. At this point, I'll just mention that she testified and admitted that out of 161 pages of medical records over 2 years, there was no mention of any cuts, scratches, anxiety, PTSD, or anything else. Counsel noted that we called Dr. Rosenberg, who is a lifetime board-certified medical doctor who specializes in psychiatry. He has impeccable credentials and decades of experience. He, by the way, does not work on a lien basis. He does not work, we paid him, he does not work on a lien basis, so he doesn't have the same incentive that Dr. Mulliken has to spin his story. Dr. Rosenberg wasn't asked to diagnose any psychiatric conditions that plaintiff has. So in this report, he specifically said no diagnosis. But he did come to conclusions, okay, which is different than a diagnosis. And what he did was he had a 6-hour recorded interview of her, and he had her take a gold standard test of 335 questions. And what he learned from the test was that she claimed symptoms, different symptoms, and so many symptoms that only 2 out of 1 billion people in the world have those symptoms. He also testified that there were inconsistencies with her story. We talked about the McKenzie analysis, in fact, that the plaintiff didn't mention any problems or physical injuries to Dr. McKenzie. We've talked about the initial incident report, which says a scratch on the nose, but not a scratch on the. So with all these different inconsistencies, that went into his analysis as well. Now, he also considered that in the Kaiser medical records, there's no indication of any of those injuries. And counsel, for some reason, focuses on vaginal discharge to say, well, if you're going for that, you're not going to mention a cut or scrape. But that's not what Dr. Rosenberg testified to. He testified that in April 2022, plaintiff went into Kaiser for a complete history and physical, and plaintiff specifically in questioning denied any kind of mental health issues, including anxiety or sleep problems. In April 2023, she went in again, and for hand pain that time, and she was specifically asked, Dr. Rosenberg said that's what Kaiser does. They ask you about everything, just noted in the records. And she was asked, but again, reported no emotional problems and did not request mental health assistance. I should also mention this claim about PTSD. Dr. Rosenberg testified that you can't, quote unquote, an argument or an unpleasant interpersonal interaction isn't a trauma and can't lead to PTSD. The claim of PTSD is frankly an offense to those people who actually have it. She had a 45-second argument. She was fired. That is not what gives you post-traumatic stress syndrome. And we know that because we've heard it from a licensed psychiatrist who did all those tests and interviewed her for 6 hours. I should mention that Dr. Mulliken is a plastic surgeon. He's not a psychiatrist. So Dr. Mulliken couldn't and didn't rebut Dr. Rosenberg's conclusion that plaintiff is feigning. Counsel said, well, why didn't the defendants call a plastic surgeon expert? Because we don't see a scar. To call someone to say, can you examine this person? Do they have a scar? You can look at the photograph. Why would we call a plastic surgeon? Conversely, though, they want to prove that plaintiff had psychological injuries. Why didn't they call a psychiatrist? Let's talk a little bit about plaintiff's shifting stories. First of all, plaintiff alleges that Cardi spit on her. It's a disgusting allegation, of course, and I hate to even mention it. And everyone else says it didn't happen. But for her part, plaintiff also hasn't gotten her story straight. If you remember, last Monday she testified in her February 26, 2018 incident report. Plaintiff told her supervisor that Cardi spit on her before people came out of the doctor's office. But at her deposition, plaintiff testified that Cardi spit on her after they came out. She can't get her story straight. That's that simple. Counsel has referred to spittle. And so what he's basically backed off of is initially it was a terrible spitting at her client. Now it's, well, maybe it was an accidental spittle, say it, don't spray it kind of thing from junior high school. There's no evidence that that happened, but it's also not an assault. It's also, when you look at the jury instructions, you'll see that an assault requires intentional conduct, intentional battery. Accidentally, spraying a little bit of spittle when you're arguing, that is not an assault, and there's no evidence that it even happened. Plaintiff also is strikingly inconsistent regarding her claim that Cardi touched her. We'll go through this quickly. We talked about in the February 26, 2018 incident report, supposedly Cardi scratched plaintiff's nose. In April of 2018, plaintiff told Dr. McKenzie that Cardi almost touched her. In sworn responses in discovery in this case, plaintiff stated under oath that Cardi viciously beat plaintiff about the head, face, and body. You haven't heard that, in this trial. No one said that occurred. In her deposition, plaintiff stated under oath that Cardi struck her on her nose and cheek, and plaintiff acted out Cardi jabbing plaintiff's face with an outstretched index finger, which is directly contrary to, and you saw that videotape of that, it's directly contrary to what Dr. Mulligan testified he thought happened.
Objection, Your Honor. We're going about over an hour now.
What's your objection?
That we agreed to 1 hour.
Okay, counsel, what's your wrap it up?
Can I have 3 minutes?
Just wrap it up.
Okay. I'm sorry, there's more to talk about, but I've got to go. Ultimately, this case comes down to what happened in a minute in a medical building hallway. And to believe plaintiff, you would have to disbelieve Cardi, you would have to disbelieve Ms. Malcolm, you would have to disbelieve Dr. Finke, and you would have to ignore all of plaintiff's contradictory statements, including whether she had a cell phone, whether she had an earpiece, all that stuff. This is not a difficult case. It is not a close case. Plaintiff has the burden of proof, and the evidence is overwhelming in Cardi's favor. Plaintiff has not met her burden of proof. And plaintiff's demand for whether it's the $24 million that was testified to at trial or the $250,000 plus that you heard today makes no sense. She suffered no injury. Cardi did not do anything wrong except try to protect her baby and get to a doctor. The court will provide you with a verdict form, and we urge you that the evidence and common sense require that you answer questions 1 to 2 as no. That will skip you over to section B. We ask that you answer question 5 no. That will skip you over to section C. We ask that you answer question 8 no, which will skip you to section D. We ask that you answer question 12 no, which is then the end of the verdict, and you can have the foreperson sign it. I also want to note that for each of these questions, as the judge previously told you, 9 people do not have to agree. You can have 9 people agree on one, a different group of 9 people on another. And we ultimately, we thank you for your time, for your consideration, and you know how we wish you roll. So thank you.
All right, and folks, as we indicated, plaintiff gets the first and last word, so time for a rebuttal case for plaintiff.
Good afternoon. Thank you all for coming back. So this is the end of the road now. I said a lot of things this morning, and I basically don't want to repeat all of it. The main point that I want to highlight, which what counsel has brought up, is the incident report. In the incident report, Ms. Emani Ellis tells her supervisor that the defendant put her fingernail into her face. You will see that. Into her face and scratched her nose. She caused damage to her face. It was a physical contact. As far as the spitting, I never brought up the word spittle. I don't know what that exactly means, but in either event, Emani Ellis, who was there, who was a witness to this incident, testified that the defendant spit on her, actually spit on her, which is an assault and a battery. Everybody gets an attorney. Everyone gets to have an attorney. Even Cardi B gets to have an attorney. All of these comments and all of these things are smoke and mirrors to hide up the truth. Bottom line is, Miss Emani Ellis, who was there, testified multiple times She never did anything wrong in her life. She was a model citizen, good person. And she basically was doing her job as a security guard, and the defendant refused to cooperate, caused a disturbance, physically assaulted and battered her, spit on her, took a swing at her, and ultimately a couple of witnesses came after the fact, and they were not witnesses to the entire incident. The entire incident really took place between Emani Ellis and Cardi B. And it really is going to come down to, who do you believe? Who do you believe? Are you going to believe Emani Ellis, who was a security guard, who did her job, who was there, who never had any problems of any kind? Or are you going to listen to somebody who's yelling and screaming, has anger management problems?
Objection, Your Honor.
Got angry on that day. There's no question. She admitted it. She said she was angry. She got angry. She attacked the plaintiff. She spit on her. She used the N-word, disrespectful. She took a swing at her. She did everything possible to cause her so much emotional anguish and try to get a reaction out of her. I don't know how it was that Emani Ellis was able to contain herself, maybe because she is so peaceful. You heard lots and lots of testimony about how she was peaceful. The issue with Dr. Mulliken, at some point I did ask Dr. Mulliken, could this cut have been done by someone who's left-handed or right-handed? At the end, he was very clear. You can ask the testimony to be read back to you. He said it could be done by either a right-handed person or a left-handed person, either one. And when we had Cardi B on the stand, she said she was disabled because she was pregnant, but at the end of the day, she wasn't disabled with her hands. And you can cut someone with either hand, both hands. Go to the bench press, both hands. Anything can happen with both hands. This is not somebody who was taking a swing with a basket. In baseball, you must use the correct. No, this injury could happen with the right hand or left hand, and Dr. Melka clarified that and said it could happen with either hand. Again, the evidence that needs to be brought forth needs to be proven by a preponderance of the evidence. We don't have to prove 100%. We have to prove a featherweight more than 50%. In this case, we have given you so much different evidence from different people, which was Emani Ellis, her grandmother, her mother, and all of the medical records. We have a plastic surgeon who came here and explained everything. You now have the case before you where you can now determine what you feel Emani Ellis should receive to make her whole. And counsel brought up some points to try to maybe muddy the waters in a sense and try to change what really happened here. At the end of the day, we have overwhelming evidence that Emani Ellis was assaulted and battered, and we thank you for your service.
All right, thank you, counsel. All right, ladies and gentlemen, that concludes the presentation of evidence and argument. You're now going to be shown to the jury room. We do have a hard stop at 4:30, and by no means would I suggest that you should try and rush to be done by then. You do need to deliberate and consider all of the evidence before answering the questions on the jury form. And so if indeed it takes you longer than 4:30 today, then we will need to come back tomorrow. If you want to take a break, you can take a break, but you all need to be back together in the jury room. So please do not deliberate until all of you are back together. To the extent that we do come back tomorrow, if you want to bring snacks or anything like that, that's fine. We can discuss that a little bit later. But for now, can I have Cynthia swear in Vanessa, please? Yeah.
Please raise your right hand. Do you solemnly swear that you will take charge of the jury and keep them together, that you will not communicate with them yourself, nor allow anyone else to communicate with them upon matters connected with the case, except on order of the court, and when they have agreed upon a verdict, you will return them into the court, so help you God?
I do.
And do you solemnly swear that you will take charge of the alternate juror and keep her apart from the jury while they deliberate, on the cause until otherwise instructed by the court's OB-GYN.
I do.
May I please have you state your first and last name for the record?
Vanessa Garcia?
Thank you.
Vanessa,
Yes, ma'am.
I want to talk to the alternate before she goes.
Grab your pens, notebooks, and personal items, and we're going to go ahead and head into that jury room. Your number 8 can make it away. Your number 7 can make it come up. And that alternate, if you could just stay in your seat. Thank you.
And counsel, do you see that the door's closed? There it is. Okay. All right, we're still on the record outside the presence of the jury. We do have the alternate number 1 here. Ma'am, on Wednesday, did you have any conversations with any of the witnesses? Were you sitting? Yeah, you.
Me?
Yes. Were you outside? Did you sit next to the plaintiff's grandmother on Wednesday?
The grandmother?
Correct.
I can't remember, but I did sit once, at least once.
Did you have a conversation with her?
I don't remember what I said if I did.
Okay, so she didn't say anything.
I didn't say anything about this.
Nothing about the trial.
No.
Okay, very good.
Not at all.
Vanessa's
God
going to
only knows.
excuse you to the jury room. All right. Thank you, ma'am.
I'll take your notebook,
Thank you.
and then I'll take your.
Thank you.
And just for the party's information, they were seen, they had some kind of conversation, may have been innocent, I just wanted to rule out an improper contact.
Thank you.
If you could please either stay close or give a cell phone number to Cynthia. You just please stay within a couple minutes in case we get any questions from the jury or if we get a verdict.
Your Honor.
Yes.
So I do want to put something on the record, but not about counsel.
Okay.
I think it's important. I think this court has a duty to handle the situation, which is what happened. During the lunch hour, Cardi B went outside and threw something at one of the news reporters. I have it on video. She's been staring at my clients, all 3 of them, trying to intimidate them. I think it's unfair, and it's they feel scared. They feel scared about what she may do to them because of what she did to that court reporter, which I have on video.
To the court reporter?
I'm sorry, to one of the news reporters. She threw an item at the news reporter physically in front of this courthouse on court property outside this courtroom. So I would ask that she be admonished and be told not to handle herself in this way and not to look at my clients anymore.
All right, so the court can't make any orders for conduct that the court didn't witness.
I can show the court the video.
Well, I still haven't witnessed it. To the extent I think it appropriate that the parties be courteous to each other. I don't think it's appropriate for anyone to be either threatening anyone or even by way of staring at someone. People can take offense to that. So please continue that courteously with each other.
May I just add one thing?
Sure.
I've been sitting here throughout the whole trial. Plaintiff has never looked this way, so I don't know what she's talking about.
Okay.
Second, plaintiff is halfway between Cardi and the jury box and the witness. I have never seen Cardi do anything else other than watch. Sometimes she, in response to a witness, may wonder like what, but I have not seen anything that plaintiff's counsel has claimed.
Okay. All right. And we do have extra security here just in case there's any kind of issue. All right. All right. Stay close.
Yes, thank you. over and over and over again, and all the jury sees is me objecting.
Back in the record.